Hello, everyone. I'm Leanne Jackson, Senior Law Editor at Forbes, and I am joined today by Heidi Vaccaramo. She is a partner at Fox Rothschild in Los Angeles, where she is a transactional lawyer specializing in music. And Heidi, thanks so much for joining me today.
Thank you so much for having me.
And we have you on in a timely manner because there's a lot of controversy going on between artists who have their music played at rallies. Sometimes it's on social media in the background of videos. And we're hearing a lot of recent cases. In fact, one of the first cases actually was involves litigation that's gone to court is Isaac Hayes. The late Isaac Hayes, one of his songs was being used at a Trump rally. And that they sent a cease and desist, of course, but also the court also ruled on a preliminary injunction. And we can talk a little bit more about that. But that is in the news right now. But we're going to discuss how many artists are complaining and what artists' rights are in these situations and how this all works, because it's very confusing, whether it's fair use or copyright. So we're going to talk to you a little bit more about that. So we're glad to have you on. So let's just start with Isaac Hayes, who a federal judge in Atlanta ruled that the Trump campaign must stop using his 1966 hit,
Yeah.
Hold On, I'm Coming. Now, he co-wrote that song, but it was performed even at the rally by someone else. They wrote it for, I think it was Sam Moore, and
Mhm.
he performed at the rally. So there's a question of he's performing it, wanted to perform it. Who owns the copyright? How does this all work? If you could just kind of break down what we're looking at here.
So in the United States, we have a complicated licensing structure. The US copyright law recognizes a copyright on the master recording itself. So it's the sound recording and the musical composition. And the musical composition is composed of the words and lyrics. And that can be a variety of songwriters, right? You can have somebody, the 2 to 4, or you can have a sample as well. So on the that's why our licensing structure is so complicated, because in order to properly obtain the license to use a song, you need to get it from all the parties, not just one. So if you're looking at in this case, like if a song is performed by a third party, then they would still have to go get clearances from the songwriter. So in this case, we were talking about the Isaac Hayes Estates, who's one of the co-writers. They would have to obtain a license from the Performance Rights Organization. So those are your ASCAP, BMI, CSAC, and GMR. And those organizations are performing rights societies that license public performance uses. They normally license locations like your bars, your grocery stores, convention centers, but neither of those licenses include the right for political campaigns or rallies. So any politician who's interested in using any music would have to go obtain a separate license for their respective campaign, which would last for the life of their campaign up until they're in office, but not past that.
And so it's a confusing structure. There's
Yeah.
multiple parties involved. There's like you said, the licensing, the performance rights, the copyright. And really a way to avoid all this is to get permission from the artists. But in most cases, I shouldn't say in most cases, but well, in these cases that we're hearing about in the news, permission has not been obtained. And that is one of the big sticking points
Right.
for the performers who say, I wasn't even asked about this. And if I had been, I would have said no. But in this case, this is the first artist to take legal action. The co-writer pursuing a complaint, David Porter, he was co-writer with Isaac Hayes on this song, Hold On, I'm Coming. So the Trump campaign did say they're not going to perform this or use this song anymore. However, and I'd like you to speak to this, there's an issue when there's videos involved. Like the judge said, you don't have to take down videos that already are using this music. And so those are still up. So there's a
So
little
yeah,
bit
so
it's a
that's going
bit
to
of
be
a
the next stage of the case. Whenever music is used in connection with moving images, like in a video, you have to obtain a synchronization license, which would require the master recording and the music composition. So in this case, right, whether it's on social media, YouTube, or used on a TV commercial, you would have to go to the respective songwriters and the owners of the sound recording. You wouldn't have to go to the PRO in that case, but you would have to go to those owners. And at any stage of this, whether there's 1 or 4 writers, and let's just say 3 writers approve and a 4th denies the use, then the use is considered denied because they don't have full approval.
Well, the Trump campaign, in defending their use of the music in all these situations, are often saying, well, first of all, that, everyone always brings up the First Amendment. They also
Yeah.
say we have a license, and that goes to your point of getting a license from these organizations, the performance rights organizations. They say there's debates about who actually has the copyright, and then there's also like have you suffered harm, which is the crux of any legal case. What are your damages? What are your thoughts on these arguments in defense of utilizing these songs without gathering permission? Especially, they get these blanket licenses and they think they just shoot their shot,
Right.
gonna use it, see what happens next.
Well, I'm an artist representative, so I always believe in the rights of approval by an artist and being able to have approval over their creative works. So, whether they join an organization like ASCAP, BMI, or CSAC, they still have the right to go to that respective organization and let them know, hey, I want to exclude my works from use in any political campaigns. Otherwise, then when ASCAP or any of these PROs license in public locations, then they can include their catalog of works. So there's an element of having to be proactive by the artists themselves or their respective music publishers who administer their rights.
So if you haven't specifically excluded, maybe on the front end, that I don't
Mhm.
want this used in political settings, then are you just out of luck, or can you go
Yeah,
back and
you can go back and let them know that you don't want to use it. So that's why you're seeing a lot of these cease and desist. And sometimes even if you have already excluded, you'll see that some political campaigns choose to use the music and run the risk, but it's usually a lot of this ends at the cease and desist level. So as you saw in Isaac Hayes, it's one of the very first cases to go to court.
yeah, and they're saying that they are going to cease and desist, but then they're at least the co-writer is still pursuing again
Mhm.
the damages. Because again, and if the estate of Isaac Hayes said they're glad that this result happened, but it's not just about politics. They say it's about the brand, the that
Correct.
implies endorsement, it damages their reputation. Is this what you hear from a lot of artists? And in terms, like you said, that an artist wants to maintain their image and how they're perceived and the light that they are displayed in.
Correct. That's the most important part of an artist's career, their brand, their name, image, and likeness, and how it's being used. So the element of false endorsement, where a song is being used in a campaign that wasn't approved by the artist, could connote that they're endorsing this candidate without, and then it doesn't have any permission to do that.
Yeah, and this is not the first time, not by a long shot, that it's particularly the Trump campaign has faced allegations of unauthorized use of music, or at least where permission wasn't given. There starting in 2020, when
Mhm.
artists like Bruce Springsteen, Rihanna, Phil Collins, Pharrell, Guns N' Roses were some of the artists who wrote cease and desist letters. Sometimes you see them posting on social media, like, I did not authorize the use of this music. Currently, of course, most recently, Celine Dion, My Heart Will Go On. That was in the news recently. Foo Fighters, My Hero. Now we're talking about Isaac Hayes, and ABBA also has complained about this as well. What do you find usually happens in scenarios like this? Music's taken down, it all goes away. Or
Yeah.
is there ever a situation where an artist has gotten damages from, in particular, a political campaign where this has happened?
I'm not sure about any particular cases. I know that in the Isaac Hayes case, they are making the claim that there are punitive damages due to potential losses in other licensing because they were falsely, it appears to them like they were falsely endorsing the campaign. So if they're able to prove that they lost out on other licensing opportunities for not just this song but any other of their works, then they would be able to prove additional damages.
So, what is the best? What is best for an artist to do, or a campaign, or any politician to do to make sure that they're not on the wrong side of the law when they
Yeah.
say, you know what would sound good? Is this song at the back of, even like we're talking about tweets here, we're talking about social media posts, correct?
Yeah. I mean, listen, I think that's the bigger reason of why this has become such a bigger issue because all of these moments are living online and we're more connected now than ever, right? You used to just be like you'd watch the news and you might hear the song, but now it's living in our phones constantly and we're scrolling through and seeing these politicians and campaigns happening. But I think it's a twofold response, right? We as artist representatives need to be proactive with our artists and understand whether or not, hey, are you interested in this? And if they say, no, we want to exclude our works, if a particular licensee wants to approach us about our use, then they need to come to us. So then we, as their reps, go to their respective music publishers and the record label and let them know, hey, we want to exclude these works. If someone comes, please note you have to obtain approval from all of us and let us know ahead of time. It's also the PROs who are also being proactive and reminding their artists, if you don't want to be a part of this, then send us notice about this and let us know what works you want to exclude. Recently, we were approached by ASCAP, who is proactive and has created a whole facts and answer questions on their website where an artist can send them a notice letter regarding excluding their works.
Yeah, there's a lot of artists to think about. They obviously have to have a great attorney, like you, someone who knows the business, knows the all of the ins and outs, particularly of copyright and performance licensing and that sort of thing. Most recently, most famously, Vice President Kamala Harris has been using Beyonce's
Yeah.
Freedom in
Mhm.
a lot of ads. She did get permission, was granted permission by Beyonce, and interestingly, I understand that former President Trump had briefly used that song as well. It's clearly a song that resonates in terms of patriotism for
Correct.
a lot of these candidates. He used it briefly, and I think she did she send a cease and desist, I believe is what I heard.
I believe so as well. And it's not just Beyonce, it's any of her co-writers and the owners of the sound recording as well. So it's, well, Beyonce is probably the bigger name. There's probably several songwriters who were also sending their own cease and desist because they have the rights of approval too.
Yeah, anyone can object, and as we know now, it's a village that's writing these songs and behind a
Yeah,
lot of these
exactly.
hits.
Mhm.
So, is there anything I haven't asked you about this issue that would be interesting for the public to understand? I mean, we tossed out a lot of terminology, licensing, ASCAP, all
Yeah.
sorts of the PRO, which is the performance rights organizations that allow this to happen. What is the takeaway here that the public needs to know?
I think that each campaign should have their respective attorneys who deal with this on the daily basis and are able to understand the complicated licensing structure or hire a company that can help you do that ahead of time.
And also, I do have another question though. Are some of them kind of like, yeah, because you see this in the commercial space as well, where they say, well, we're just going to use this and see what the fallout is. Because a lot of
Yeah.
them should know better. You see that on TV, you've heard of television commercials where they've used a song without getting licenses, without paying for the rights. So is some of it kind of like, let's just try it,
I
see what
know. As an attorney, I'm honestly not a fan of asking for forgiveness. I'm a fan of asking for permission.
Right. There's the takeaway. Ask for permission first. So thank you so much. This has been a really fascinating discussion because everyone knows these songs, everyone hears them and wonders about it. So I appreciate you taking the time to break down and help us understand a little bit about how this works.
Perfect. Thank you so much.